Imagine two classrooms in the same city. Actually, let's make it tighter than that.
Yeah.
Imagine two classrooms in the same building, just down the hall from each other.
Okay.
In room A, you have 34 students packed in. I mean, it is loud, it's chaotic, and if you're a kid in the back row, good luck getting the teacher to even see your hand is up.
It's the classic picture of an overcrowded public school.
Right. But then
Yeah.
you walk down the hall to room B,
Yeah.
and it's a different world.
Mm-hmm.
There are only 25 students. There's space to breathe.
Mm-hmm.
The teacher is actually sitting with a student,
Mm-hmm.
one-on-one. And here's the kicker. The deciding factor for which room you get into isn't your grades. It isn't your special needs status. It's the color of your skin.
You know, that sounds like something from a history book. But we are talking about Los Angeles right now in January 2026.
Welcome back to the Deep Dive. Today we are unpacking a story that is making waves not just in education, but really in the entire American legal system.
It's good to be here.
We're looking at a federal lawsuit filed against the Los Angeles Unified School District, LAUSD, that claims the district is running a two-tiered system that overtly discriminates against white students.
And you're right to frame this as bigger than just schools. This lawsuit, filed by the 1776 Project Foundation, is arguably the first major test of the new legal reality we're living in since the Supreme Court really shifted the ground beneath us last year.
We've got a lot to get through today.
Mm-hmm.
We have the legal complaint itself, we have internal memos from the district, and a breakdown of a Supreme Court case called Ames v. Ohio.
Right.
But let's start with the news hook. What exactly is going on in Los Angeles? Because overt discrimination against white students is a very heavy charge.
It is, but the lawsuit argues the math is just undeniable. Here's the situation. LAUSD has this funding formula to achieve what they call equity.
Okay.
Under this system, if a school has a population that is at least 70% non-white, it gets designated as Group 1 school.
Group 1. And what does that get you?
It gets you the golden ticket. It triggers a mandatory cap on class sizes. If you're in a Group 1 school, your English and math classes are capped at 25 students.
25.
But if you're in a school that doesn't meet that racial quota school with more white students, the cap is lifted to 34.
Wow. That's a difference of 9 students. I mean, that's huge.
It is massive in terms of teacher attention, classroom management, just the ability to learn.
Mm-hmm.
That's a completely different educational product.
So the lawsuit is basically saying that the district's message is, if you're white or if you go to a school that's too white, you get a lower quality of education.
That's the core of the complaint.
Okay, let me play devil's advocate for a second. The school district isn't just coming out and saying, we're doing this because of race, right? What's their justification?
Their justification is equity. They argue that Black and Latino communities have faced historic disinvestment. So they need to pour more resources into those specific schools to level the playing field.
And they have a name for this.
They call it the Student Equity Need Index, or CNI.
CI. And I'm looking at our notes. This index uses some really specific data points, things like asthma rates, gun violence.
Right. And this is where we have to get into the weeds a little bit, because this is where the legal battle is really happening. The district uses what they call indicators.
Okay, but asthma is a health condition.
Mm-hmm.
It's not a race. A white kid can have asthma. An Asian kid can have asthma.
In theory, yes.
Yeah.
But the lawsuit argues that these are what we call proxies.
Proxies.
A proxy is a stand-in. The argument is that the district knew they couldn't legally just say, we are giving more money to non-white kids.
That would be too obvious.
Way too obvious. So they went looking for data points that correlate almost perfectly with the racial demographics they wanted to target. And in Los Angeles, if you map asthma rates and gun violence, you are, in effect, mapping race.
So it's a workaround. They're using asthma as code.
That is the allegation. And the result is stark. The highest need schools, the ones hitting these proxy markers, get 31% of the equity funds. That money buys psychiatric social workers, climate advocates, and crucially, the extra teachers needed to get those class sizes down to 25.
And meanwhile, a kid in a different zip code, maybe a white kid whose family is struggling, but the neighborhood doesn't trigger the gun violence stat. They get put in a crowded room.
Exactly. And this is the core of the conservative critique here. It's the zero-sum argument.
Zero sum, as in, if I win, you have to lose.
Precisely. School budgets aren't infinite. It's a fixed pie. If you spend millions hiring extra teachers for Group 1 schools, that money has to come from somewhere. It comes from the other schools.
So by prioritizing one group, you're actively penalizing the other.
That is the argument, and the district is actually pretty explicit about their goals. We have documents here about the Black Student Achievement Plan, or the SAP.
And this isn't about proxies like asthma anymore, is it?
No. The BSAP is explicit. It funds things like Black cultural arts passports, tours of historically Black colleges and universities, and STEM makerspace labs that are designated for these specific populations.
Hold on, designated. Let's unpack that. If I'm a student at that school, but I'm white or Hispanic, can I get into the STEM makerspace lab?
According to the complaint from Parents Defending Education, the answer is effectively no. These resources are ring-fenced. They're designed to, and I'm quoting here, cultivate positive cultural identity for Black students.
That feels, that feels legally dicey. We're talking about a public school with taxpayer money. Can the government really run a blacks-only club inside a public high school?
Well, under the 14th Amendment's Equal Protection Clause, the answer should be a clear no. But for a long time, districts have operated under the assumption that if the discrimination is benign, if it's meant to help a marginalized group, then it's okay.
Benign discrimination. Like, we're doing this for a good cause, so look the other way.
Exactly. But that entire defense is crumbling. And this brings us to the elephant in the room. The reason this lawsuit is happening now, in 2026, is because of the Supreme Court. We need to talk about Ames v. Ohio.
Okay, yes, Ames. This was a big ruling from June 2025. Break it down for us. Why is a case from Ohio changing what happens in a classroom in LA?
Because Ames completely changed the rulebook for discrimination lawsuits. To get why it's a big deal, you have to understand how the law worked before 2025.
I thought the law was just don't discriminate.
You'd think so, but the courts had invented this really tricky concept called the background circumstances rule.
Background circumstances. Okay, what does that actually mean?
It means that if you were a member of a minority group suing for discrimination, the track was flat. You just had to prove you were treated badly because of your race.
Simple enough.
But if you were a white person, a member of the majority, the courts put a massive hurdle in your lane. Yes. They assumed that because white people are the majority, it's very unlikely they're being discriminated against. So before you could even present your case, you had to prove these background circumstances.
You had to prove the world was upside down just to get your foot in the door?
That's a good way to put it. It made so-called reverse discrimination cases almost impossible to win. But in Ames v. Ohio, the Supreme Court took a sledgehammer to that hurdle.
And this wasn't a close 5-4 vote, right?
Not even close. It was unanimous, 9-0.
Wow.
Liberals and conservatives all agreed. They struck down the rule. Justice Clarence Thomas wrote a concurrence that's now famous. He said, "There is no such thing as reverse discrimination. There is only discrimination."
There's only discrimination.
Yeah.
That's a powerful line.
It simplifies everything. It levels the track. Now, the 1776 Project doesn't have to prove that LAUSD is unusual. They just have to prove one thing. Is student A being treated differently than student B because of race? If yes, it's illegal. Period.
So the district can't use the good intentions defense anymore. They can't say, we're just trying to fix history.
No. The Supreme Court has made it clear. The why doesn't excuse the what. You cannot fix past discrimination by practicing present discrimination.
But wait a minute. Let's go back to the proxies, the asthma thing. Even with Ames, can't the district just say, we aren't looking at race, we're looking at health data. You can't prove we're being racist.
You might think that would work. But the legal world saw this coming. We have a memo here from a huge corporate law firm, Munger, Tolles & Olson. They wrote this back in 2023, warning their clients that the proxy game was over.
They called it that.
Essentially. They warned that if you use race-neutral measures like zip codes or health data, but your intent is to achieve a racial balance, the courts will call that pretext.
Pretext, so it's a lie.
It's a mask. And the courts are allowed to rip the mask off. If plaintiffs can find emails or speeches where the district says, we are doing this to help Black and brown students, but the official policy says we are helping asthma patients, the court looks at the intent.
And in LAUSD's case, are they hiding their intent?
Not at all. That's the problem for their lawyers. The district has been shouting from the rooftops about their commitment to racial equity and the Black Student Achievement Plan.
So they basically handed the evidence to the plaintiffs.
On a silver platter, under the new Ames standard, admitting your engineering outcomes based on race is basically admitting to a constitutional violation. The district thinks they're being virtuous. The Supreme Court says they're breaking the law.
You know, it seems like we're watching the end of an era. For the last, 50 years, we've had this idea that affirmative action and these kinds of equity programs were the right way to fix things.
That's right. We operated under a system where equity meant equal outcomes. If Group A is doing better than Group B, you have to hold Group A back or give Group B a boost until the numbers look the same.
And now?
Now we are moving back to equality. Equality means everyone gets the same rule book, everyone gets the same starting line. If the outcomes are different, the government isn't allowed to step in and rig the game.
So what happens if the 1776 project wins? Does the Black Student Achievement Plan just vanish?
It probably gets dismantled or radically rewritten. They would have to open up those makerspace labs and college tours to everyone. They'd have to allocate funding for small class sizes based strictly on need-like family income or test scores without any of this racial arithmetic.
So a poor white kid would get the exact same resources as a poor black kid.
That is the goal of the lawsuit, to strip the racial labels off the students and just look at the individual.
This has to be terrifying for companies too, right? This goes way beyond schools.
Oh, absolutely. Think about it. How many companies have diversity fellowships or internship programs that are only for underrepresented minorities?
Pretty much all of them.
Well, under the Ames precedent, those are legal landmines. If you have a program that excludes white or Asian people based on their race, you are a sitting duck for a lawsuit.
And now that the background circumstances hurdle is gone,
Any employee who feels they were passed over for a diversity hire has a straight shot to federal court. The entire DEI diversity, equity, and inclusion industry is facing a reckoning.
it's just fascinating that we're circling back to the original text of the Civil Rights Act of 1964. It just says, do not discriminate. It doesn't say, unless you have a really good reason.
Yeah.
It just says, don't do it.
And that's the central paradox. The courts are finally resolving it. And the answer seems to be, discrimination is never the cure for discrimination.
I want to leave our listeners with that image we started with. The two classrooms, room A with 34 kids, room B with 25 kids.
The visual that proves the two-tiered system.
So here's the question for you. If a school district has to discriminate against a child today, deny them a teacher's full attention, deny them space to fix a mistake from 50 years ago, have we actually made progress? Or have we just changed who the victim is?
That's the question the country is grappling with. And right now, the courts are saying, no more.
We'll be watching this case closely. It's going to set the tone for the next decade. Thanks for diving in with us.
Always a pleasure.
We'll catch you on the next deep dive. Stay curious.